afternoon, Mr. Rozenholc.
Good afternoon,
And
Judge.
thank you for coming to participate in our commemoration of the 40th anniversary of the New York City Housing Court. As a start, what was your experience in landlord-tenant matters, for those that don't know you?
Okay. I was Director of Litigation at South Bronx Legal Services, which was a legal services office that was specifically dedicated to representing tenants. My recollection is we had 10 attorneys, and we did only landlord-tenant, meaning representing tenants in the Bronx.
Okay, now, did this section of legal services exist prior to the formation of the Housing Court?
That, absolutely. We were, yes. Yes.
And what was the experience like having to represent a tenant, say, in a non-payment proceeding prior to the formation of the Housing Court?
If I may, what I would like to do is discuss my experience as to what was going on in landlord-tenant court in the Bronx specifically, and I'm sure in other boroughs, even before legal services appeared on the scene and where tenants really had no representation at all. In the Bronx, there was one judge who was assigned to landlord-tenant. The judge heard both commercial and residential cases, heard all cases. The calendar in landlord-tenant court in the Bronx on a typical day was finished before 1 o'clock. Most cases were defaulted. There was an enormous problem of sewer service. In addition, as we know, there was no warranty of habitability, okay, as part of the law. So the tenants who did appear would appear without an attorney, because obviously most tenants could not afford an attorney, and by 1 o'clock they would have had a final judgment. If there were repairs which were necessary, the judge may tell the landlord, do the repairs, make sure you do the repairs, but ultimately very few tenants walked out of that court without a judgment. The courthouse was controlled by several attorneys, basically in each borough represented the landlords. Literally, at least in one case, one of the attorneys had the keys to the courthouse. So obviously, tenants had a very, very difficult time getting their issues dealt with in that court. When legal services appeared on the scene, as I said, we had 10 attorneys. Tenants would come to us, and obviously, for the first time, an answer would be put in response to the petition. There would be motions which were made, and finally the court had to be a court. But as I said, there was still at the beginning, after legal services came into existence, there was still only one judge sitting at the commercial and the residential part who dealt with all the cases. You can imagine that if you walked into court, and after a while you would accumulate a number of cases, you would walk in and you had an answer, you had a motion, and you were ready for trial. If a judge did one trial, nothing else happened in that courtroom that day. Okay, so after some period of time, what would happen is, at one point, they got another judge, a backup judge. So now we had two judges, calendar judge and a backup judge. But the reality is that two judges could not handle the number of cases which really existed once tenants got representation.
Approximately how many cases would you be talking about on the calendar in any given day?
There were my recollection is there were hundreds of cases. 100 cases or more than 100 cases. I would know, we would walk in after a while as a result of being ready for trial basically in every case, have traverses in most cases because, as I said, sewer service was a real problem at the time of the Bronx. Anybody who was there knew that was a real problem. What would happen is after a while, we would send two attorneys into court because there were two judges, and they would walk in with 80 files. And if you were ready for trial in every case in 80 files, obviously, the system did not accommodate it. But one of the reasons we did that, and let's just be very frank as to why we did it, our experience, as I said, no warranty habitability claims. My experience was, and our experience was, that the most effective way to get a landlord at that time to do repairs and give you a decent abatement was to withhold as much rent as possible. And that was the reality of the leverage that existed at the time. We have to remember, by the way, there was it was a different bar, different situation. My recollection is that the typical, what they called at the time, a dispossess, would cost the landlord $27 That's all he would pay. And that would involve, in most cases, the first court appearance for $27. You can imagine that after a while, once lawyers appeared on the other side and you had to do trials, suddenly the $27 obviously were not sufficient to accomplish what you wanted to accomplish. As a result, they started charging at the beginning around $50 a court appearance, but obviously it was a different time and things have changed very substantially.
Eventually, there was legislation to form a special housing court. And many people on our committee, we've had discussions that the primary purpose of the housing court was to maintain the housing code. There was another faction that believes that the primary function of the housing court is to be a collection agency for landlords. What has your experience been in general with the operation of the housing court?
I believe that politically, the housing court was created as a result of the situation which I just described, in which tenants were represented. There were not enough judges to cover the cases. As a result, cases were not moving. So I believe that initially, I believe it was formed because of pressure created by the real estate industry. But subsequently, it serves the second purpose that you said, which means it served a greater purpose, obviously, than the intended purpose. The intended purpose was to collect rent as quickly as possible. But ultimately, obviously, the housing court has served an important function in maintaining the housing court and making sure that tenants' rights are preserved. Landlords' rights and tenants' rights are preserved.
Do you think that this model of the housing court benefits both parties the way it exists now?
I believe that it benefits both parties as reasonably possible. You still have exactly the same problem that existed before. The most tenants who come to court are not represented. The attorneys always representing the landlords. They always try to talk to the tenants outside the courtroom, and I know judges are very careful to make sure that nobody takes advantage of a tenant. But on the other hand, the judge is a judge. The judge cannot be the advocate for the tenant. So the problem of most tenants not being represented, and the reality is the legal services and legal aid today have many less attorneys, less committed attorneys that existed at the time. It was a different political time. And as a result, most tenants are still not represented. And one of my concerns is, as you sit in a courtroom and you see a landlord's lawyer talking to a tenant who obviously knows nothing about their rights, that somehow, the housing court has to deal with that situation. And I know it's a very difficult situation for judges to deal with.
How do you feel the initiative impacted the New York City housing court?
The initiative?
The housing court initiative that was implemented in 1997, where there are parts that are solely dedicated to the resolution of cases and solely dedicated to trial.
I believe initially when the housing, my recollection of the Bronx, we had 5 judges who were basically backup judges, and cases were called in the calendar part and sent out to the judge. They were not sent out for resolution. They were not sent out. They were sent out for all purposes. Mm-hmm. And judges both tried to resolve cases and try cases. I believe that the creation sort of a dual system with resolution and trial, does, I think, serves a function, because judges and resolution parts would have more, let me just say, if they had less cases, they would have more time to try to conference cases to see if they could be resolved, and only send them out to trial if it was necessary to send them out to trial. So I believe it's a useful function. I mean, over the years, other things have happened. As I said, we used to have an enormous problem with sewer service. And tenants really didn't know that that literally sewer service was sewer service. Tenants did not know there were cases in court. I mean, ultimately, at one point, the court started sending postcards. That made an enormous difference, because people suddenly, if they were not served with a petition, notice petition, got a postcard and got some notice of the fact that there's a case pending and they have to do something about the case.
Okay. In your practice, have you ever utilized the HP part?
I've utilized the HP part.
Do you think it's an effective?
I believe the HP part is, yes. I mean, it finally, at the beginning of the process when I got involved, like very early 70s, okay, 7As was already available. But before the housing court, if we wanted, landlords could not collect the rent. But if we brought a 7A proceeding, there was no judge to try the 7A proceeding, meaning there were not enough backup judges. So the housing court served the purpose in the sense that if you wanted to bring an action on behalf of a tenant, like a 7A proceeding, an HP action, there was a judge to hear the case. There were inspectors who became available. There were never inspectors in the court. Inspectors who became available. I remember in the Bronx when we started with the housing court, judges would go, there were many rent strikes. Judges would go and actually visit the premises, visit the building, and that, that was obviously a very useful tool to resolve cases. I just want to mention one thing about the housing court, and initially, we did not like, legal services people did not like the housing court, the fact that the housing court was established, because we believed it was established basically as a result of pressure by the real estate industry to move cases. So we, I just remember, was thinking about it, the first few days of the housing court, there were no American flags in the courtroom. And we objected because the New York law requires every courtroom to have an American flag. We objected to the fact that there was a courtroom in session without an American flag. It gives you a sense. But the other thing that existed at the time, which does not exist any longer, exists to a much lesser extent any longer, there was enormous political fermentation sort of at the time. If you remember, the Bronx was actually burning. The Bronx was burning. We're in a different time now. But to give you a sense, when the housing court was established in the Bronx, tiny courtrooms, really tiny courtrooms, meaning, a desk, you were sitting 2 feet away from the judge, and there were, a couple of benches in the back. Courtrooms were packed. Outside the courtrooms, the hallways were packed. To give you a sense of what was going on, an example, which I remembered, I was doing a case of rent strike in front of Judge Thomas Sinclair, sadly, who passed away, who was one of the original housing court judges in the Bronx, then became a civil court judge. And as I'm standing and arguing my case, the landlord, who's since passed away, so I'm not going to mention his name, was standing next to me, and I looked to my right, and he's counting bullets. He had bullets in his hands, and he was moving the bullets from one hand to another hand just to try to intimidate me. Okay, I mentioned it to the judge. The judge, this was before real security, like we have security in the courthouse now. You can walk in with anything. The judge, told everybody to leave the courtroom and had everybody searched to walk back into the courtroom. That was, at the time, that was part of what was going on, and in that courthouse. On the other hand, not to compare, there were community organizers, and they at times packed courtrooms, with people just to try to impress the judge with the seriousness of their claim. As I said, initially I was opposed to the housing court. I did not believe it was going to perform any function that is useful to tenants. I believe it serves a purpose in protecting tenants also, although many tenants are unrepresented and
Well, certainly you must feel that at least having a dedicated housing court, it gives some sort of forum to tenants.
Absolutely. As I said, you have an opportunity to bring your own case. You can bring a 7A proceeding. You can have a judge hear it. You can bring an HP action. You can have a judge hear it. The more judges available to hear your issues, you want to try your case, the judges who will try your case, and hopefully they will listen and do justice in the case.
Over the years also, I think that there have been a lot of, let's say, access to justice programs where there's information given to tenants that was not available to them before. There's now computers, there's videos, there's pamphlets, there's actually a resource center. I think that there's certainly a lot more available for non-represented litigants. Not that that would ever take the place of actually having.
No, I understand, but there's no question. The fact that you can walk into the courthouse and there's someone you can talk to and ask a question when you really are not aware of your rights is useful. Does not replace an attorney, but at least you if you're a tenant, you can obtain some information.
Okay. If you could do anything to change the housing court or how it works, would you have any suggestions as to where we could go in the future?
I would try to get the best possible judges who have hearts. Okay, because you're dealing in an area which is obviously, I mean, as a judge, you're aware of it. You're dealing with people's homes. There's law, there's life. Those are people's homes, and I believe the judges who have sympathy sympathy and a heart and a good heart is, in this instance, even more important than knowing the rules of evidence.
Is there anything that you'd like to add?
No, thank you.